Okay, thank you to the panel. We have time for some questions and observations. Before we get to the questions, just an observation from my part on this. The thematic element here is in use of information, patent analytics, and what strikes me is the diversity of use which this is being put to, all through what I would call the industrial cycle of the products. And if I can take it back to my own experience, from the very early stages of R&T, analytics lets you understand what is happening in the technology ecosystem right through to the end when you're making products. What are the risks? Are you going to infringe third-party rights? So even though these are extremely diverse subject matters themselves, the use of analytics and patent searching is absolutely critical. And there's a lot at stake. So what I might do is if there are any questions from the audience, if we can start right now. So, gentleman down here. Do we have a microphone? Yes?
I just had one question on the Chinese presentation, so thank you very much. That was very informative. They were all informative. But in the Chinese rush to patent everything, I guess I have two questions. That volume of patents has to indicate that there must be a lot of issuance of patents that are less than critical to the future of humankind. I suppose that's a statement. But second, the real question is, why do so few of the Chinese patent holders register outside of China?
I believe that this may be related to the industry level and development history of the Chinese industry, because in the past years, China is in the position of learning and developing their own technology. So most of the market are inside China. And in the recent years, we can see that more and more China companies has go to investment abroad. So it's true that in the past years, the total investment abroad, which is done by the Chinese companies, not so much, and especially within these investments, the investment in high technology or in leading knowledges is not so much. So we do not see a lot of Chinese companies file for foreign applications. But we can see that in the recent years, we have already feeling that the Chinese companies will file more and more foreign applications. The table shows the data which is filed in 2012. It's about 5 years ago. Yeah.
Thank you.
There's a question down the back here.
I also had a question about the Chinese patent market. I wonder what's the reasoning behind the surge for patent filing right now in China? Is it mostly because of governmental incentives, or is it actually because of the competition between the companies that would require protection of their ideas by patent?
I'm sorry that your question is to why the Chinese companies file so large number of patents, or why we need to do a search focused on Chinese patents?
No, the first one. Why is it that now the Chinese company are filing so many patents? Is it that actually they're competing with other companies that demands protection of their intellectual property, or is it, as we have seen in other countries, that government is providing a lot of incentives or requirements for these companies to file patents in order to have like subsidies or like loans and that kind of things, basically? What is the reason that so many companies nowadays in China are filing for patents?
I believe that the most important reason is that the companies, they feel they need patents nowadays. The actual reason is that from the in the past years, we see that the government encouraged the companies to file more patents, and they have has some policies to encourage it. But now I believe that the support from the government is reduced, and it's now the growth comes from the real demand of the companies themselves, because they see that the market, that if we want their company to be competitive in the market, they need the IP rights, and patent is more and more important, because with the support and the guide by the government for a period of time, more and more Chinese companies they learned how to use the patent, how important the patent is, and now then the growth comes from the encouraged from outside, and it's now turned with the internal growth of the companies themselves.
Question down the front here.
Just a quick follow-up. Do you also see a lot of enforcements of patents in China now, or a lot of licensing agreements happening, or is it mostly just registrations of patents that has increased substantially?
These years in China, we can see more and more enforcement and licensing. It's a very quick growth, but you may feel that the ratio of the enforcement and the licensing is still quite low compared with the large base number of the applications. But if we pay attention to the absolute number, it's a very quick growth in the amount of licensing and enforcement.
If I could add something there, as a very high volume patentee in China, any patenting exercise in China is an exercise in hedging, given the lifespan of a patent. Airbus file around 200, 250 first filings in China every year. And in my career, I've seen the Chinese IP profession and legal system evolve a lot. We have significant competitors in China, so yeah, we treat it in the same way as any other market, and that's based, as said, on internal industrial growth in the internal market, not so much on Chinese manufacturers exporting outside. For us anyway, that's the most critical thing. So, just a comment. Sorry, Tony, you have a...
Yeah, I'd like to add to that as well. We've seen this before, most recently from Korea. Samsung and LG and Hyundai are some of the most IP-savvy companies in the entire world, bar none. Samsung in particular. If I had to pick the most IP-savvy company in the entire world, I would pick Samsung. And they learned it from the Japanese. And so on. There's been a continuum that as countries develop, their IP systems develop accordingly. And I think that we have now seen that phase shift with regards to what's happening in China. And I couldn't agree more with the other comments that have been made by Alistair and from Jai that we've reached that point where those Chinese patents and those Chinese patenting organizations are going to be filing much more internationally and going to be participating. And Chinese companies are buying assets outside. And there are some that feel, I was just at a conference in Chicago a little bit earlier this year, that because of the court system that the Chinese are developing, that litigation and you can actually get an injunction, for instance, in China. And they will hold to it in a very, very strict manner, which you cannot do in the United States. There are some people that feel very strongly that Chinese injunctions and litigation and the size of that market is going to make China amongst the most important IP regions in the entire world.
Another question, Dan.
Yeah, I'd like to follow that comment up. We do a fair amount of work helping clients monetize or license trademarks into China. And it's so vastly different today than it was even 5 years ago. Today, the Chinese consumer knows the difference between a phony Hello Kitty and a truly authentic licensed Hello Kitty. And believe me, they want the real thing. And you get good support today in the marketplace. There's a lot more licensing of trademarks It's a great market to work in today.
So I again have a question for you, Ms. Lu. You elaborated on having best practices for emerging businesses, how you can cut down on the costs for FTO for an emerging business. So my question is, by what % do you cut down such costs for an emerging business? Like, what will be the difference if you do the full-fledged FTO for a big organization, and when you put your best practices for an emerging business and do that selective thing, what would be the percentage by which you'll reduce the costs?
I believe your question is that how much would be the reducing costage if you do the long-term monitoring versus the emergency FTO?
Yes.
To be honest, we do not have computed this number, but what we see is that for because most of the clients that come to us for a FTO, they are a not very large company. So if the FTO, the result is not so good, if they're waiting for the high risks, the result of their company is not very good. So it's not a problem that, up till now, the problem is not that how much money you can save. The question is that you can be alive in the market or not. So some small companies come to us when they are not so good, so they actually the FTO, if the result is not so good, so the company is closed. So I'm sorry that I do not have a accurate computation of the ratio of the question, but what I see for my clients is that if you just pay attention to the FTO at the urgent time you come to us, it's a very, very high risk. And if you do in a different way, that it will be more safe for your company, because the company, for a growing company, your financial system is not so solid. You cannot afford a very expensive litigation procedure. So
my experience with FTO has been similar. No matter what strategies you adopt, the FTOs are to be done very, very diligently, and the costs are always at the same level. At the max, by implementing such strategies, you can cut down by 10% and 15%, but that doesn't really, makes a big difference to the business. So FTO being a very expensive thing, I also face this because I have a lot of startup clients, and they're not able to afford the expensive process. So I was just, that's all, that's an honest answer I've got from you. Nothing more required.
Just again, a comment on FTOs. We view them more as risk management rather than cost reduction or cost saving. The consequences of either not doing one, it is very binary, especially in our business, where we can't reverse engineer aircraft very easily. So, yeah. Well, we selectively do FTOs very carefully. Sorry, there was another question over here.
Thank you very much for the presentations. My question is, in your respective jurisdictions, how do you deal with the softwares and these mobile phone applications in terms of protection? Does it fall under copyright? Is it a patent? Or there's another mechanism?
You have a patent attorney on the file? Tony, maybe you would like to.
Well, with regards to software, there's a couple issues. Software per se is, not really patentable, but attaching it to some sort of medium or as a processor configured to do those functions is normally how, I wouldn't say normally, but it's one way of claiming it. and also avoiding one-on-one rejections towards non-statutory subject matter.
Yeah, and one quick comment. If anybody would like a copy of the slides, please just come to me during the course of the next 2 days. Give me your email address and I can send you those slides just so that you have the different examples that I showed of the different visualizations. With regards to this, it's interesting. Doing the quantum computing report, I actually had a look. A reporter asked me what was the difference, if there was a difference between the quantum computing field with regards to algorithms and software in those sorts of areas with regards to one-on-one rejections and specifically Alice rejections. Alice is a recent Supreme Court case that talked a little bit about statutory subject matter, and it's been used quite frequently. There's some studies that showed that about 4% of all the 101 rejections in the United States are citing Alice now. And so it's a relatively high number, all things considered, especially for a pretty recent court case. And what we found in the quantum computing space, though, was that Alice was used very, very, very infrequently, and 101s were also below average. And so it speaks to exactly what Blair was talking to with regards to, in this particular case, they're not trying to patent software broadly. They're trying to patent an algorithm or a software that has a specific application that's being used in conjunction with a particular device. And so it's not dissimilar to what was seen with biotechnology, gene patents. Once upon a time, people were just filing thousands and thousands and thousands on any sequence they could possibly find, having no idea what those sequences actually did. And that came to an end. And so in a similar way, there's a huge number of software patents, and they're very, very broad and could be interpreted any number of different ways. And that practice is now being brought to an end. So working with a qualified and patent attorneys that work in that space, it is very possible to get still good protection that will help you along, not just initially, but years down the road, because a good patent attorney will help you think about how that particular application can be used in other places other than the initial need. But it can certainly be done. It just needs to be done carefully.
As an ex-practicing attorney, I can agree with that. The task of a patent attorney in that case is to make the unpatentable look patentable. And this is from someone who's prosecuted and drafted many software patents. But as the law changes, you take the client's invention and you do what you need to. Sorry, over here there's a question. We have time for one last one.
I would like to thank the panelists for the presentations. I'm from Nigeria. I represent Sefton Frost, a law firm in Nigeria. The challenge we have in the IP space in Nigeria mostly has to do with counterfeiting, and mostly from Chinese companies. I understand there's a lot of local registrations and applications, but my question is to the gentleman from China. What efforts are you making to encourage cross-border registration, especially in emerging markets such as mine, Nigeria, where you have a lot of activities from companies in China? Thank you.
It's a really difficult question. I'm sorry that I need to consider for a moment. Will you please leave this question for me, and I may think for a moment and then reply to you. I'm sorry.
Myself, Dr. Abdul Qadir. In fact, I have worked in the public sector of government of Pakistan. So what I have seen with the Chinese government is that through their embassies abroad, they facilitate and they try to invite the people who are in the public service, public sector, to come over to China and to study their methodology and the procedure for seeking protection in China. And as well as they also extend support to the public sector institutions in the newly rising economies like Pakistan or like Iran or even Nigeria. So this little I know about the Chinese government, that they are supporting, extending support and protecting the IP rights. Thank you.
Okay, one last question. I think we're nearly out of time.
My question is to Blair. So when you were discussing about that use slide, NTL case law, you said that method will not be a good option to go there. But don't you think that there, in case of induced infringement, will follow? If you have the company only following one step outside the country, but it is allowing that step to happen outside the country.
So if I understand your question, was it method claims aren't helpful? What?
Wouldn't it still fall under the infringement? You said system would be better in that case.
Oh, so extraterritorially, it depends on your client or if you're in-house, your certain business needs. But for the uses aspect under 271A, all steps of the method have to be performed within the country. So you wouldn't find a remedy under that statute. You might find a remedy under 271G. And a lot of chemical and pharma cases arise under that statute where in another country they use the method to produce a certain drug and then they import it into the United States. So from that aspect, a method claim would be helpful. It essentially boils down to what every patent attorney knows. You try to get the best protection for your client or for your business. You just need to take into account these specific situations, and that's why it's very helpful if you work with a local counsel that knows some of these exceptions. So.
Thank you.
Okay, just like to thank the panel for the discussion, and also thank you for the excellent questions from the audience. I'm sure that the members of the panel will be happy to take questions in the next day or so. So thank you very much, and we'll go to the next slot.
Now I would like to request Alistair Scott to present the mementos to our speakers.